Hi, my name's Phil. I like talking about politics, and so it's on to day 2 of the Supreme Court case to decide whether the government's attempt at prorogation for 5 weeks, shutting down Parliament, was lawful or not. This one's going to be in 2 parts because the 2 halves of the day were very, very different. You had a government barrister in the form of Sir James Eadie QC arguing for the government's position in the morning, and then O'Neill for, for Scotland's position, I suppose, in the afternoon. And they were so different that I'm going to have to do it in 2 different videos. Now, it has to be said that Sir James Eadie QC, like Keane yesterday, got a bit of a roughing up from the judges, and you may feel from that a couple of things. Maybe that it hasn't gone so well for the government. We don't necessarily know that. Or maybe it's that they dropped the ball a few times. We don't necessarily know that either. What we do know is that those 2 guys are absolutely amongst the best in terms of barristers for British constitutional law. I think it's just sometimes if you don't really have a strong position to argue from, it is very difficult to win an argument when you're in the wrong. It's much easier to win when you're in the right. Now, that doesn't mean to say that they won't win the case, because ultimately they have one argument and that it's none of the court's business. And if the court takes the same view, then the government will win. But you just sort of feel, based on the arguments that were presented today and the judges' reactions, that if the judges do feel that actually it is their business, then you cannot see the government winning. So he started off, of course, Sir James, with the non-justiciability, the idea that it's none of the judge's business. It's none of your business, he said. He didn't actually say that. But he was describing it as it's a prerogative power, which basically, as I said yesterday, means that it's technically a power that the Queen has, but in reality, we don't let the Queen have political power. So it's for ministers to advise her to use these various levers. And he said that it's one that's been expressly preserved by Parliament. In a way it has, because Parliament could have legislated to stop this sort of behaviour, and they didn't, and that was stupid. He explained that Parliament has passed some legislation on prorogation. It's not that it's not legislated at all, but in areas where there isn't legislation, the prerogative remains, and that means that, it's not always going to be subject to a judicial review. Okay, maybe not. Doesn't mean to say it's not always, of course. And he also said that whether the exercise of a power is reviewable, in other words, can go before a panel of judges, depends on the subject matter and the nature and the context, so, which I would agree with. Definitely the context in this case is key. But he said the controlling factor in determining whether the exercise of prerogative power is subject to judicial review is not its source, but its subject matter. But that's so vague, you could argue that that's an argument either for saying it's unlawful or against. He did cite an example where courts sort of felt that because there weren't sufficient legal measures for them to be able to determine whether something was unlawful or to what extent, that in those cases the courts basically said, well, we can't really get involved here. And that is, of course, their key point. This is the key point for the government. In fact, it's the government's only argument that the courts can't get involved, that it's none of their authority, none of their business, because of the lack of legal standards to measure the prorogation against. If they're going to say, actually, the 5 weeks was for the purpose of stopping. Because if you prorogue Parliament for 1 week, in that 1 week, you are still stopping Parliament from holding the executive to account. So you can't just say that it's unlawful based on the idea that it's there to stop Parliament holding the executive to account. So what standard do you apply? That's the argument. What standard do you apply? And if the court doesn't feel that it can apply a set standard, then it shouldn't interfere. Now, I don't think, and of course I'm not a legal expert, that has to be really clear here, but I'm not sure that's necessarily true, because a legal standard always has to be applied at some point. And the whole point of Panic's arguments the previous day is that it was done with the specific purpose of preventing Parliament from stopping the government making a change that it doesn't have the authority to make that will affect people for decades to come, that Parliament does not want to happen. That's the effect of it. So it's not just about the scrutiny. But anyway, he went on also then to say that there's a second rationale for the courts to refuse to enter the political field, And he referenced a case, Shergill versus Kyra, 2015, which I'm not going to bother to research or anything, because Lady Hale, who is the president of the Supreme Court, had to point out that that particular judgment is not binding on this case. Eadie had to respect that and say, okay, fine. She said that's not going to affect this judgment. So essentially, what the battle here is Panic yesterday was drawing on various previous constitutional cases and presenting a rule that the Supreme Court could use to determine that the government had fallen foul of those rules. And Sir James Eadie is arguing that rule doesn't actually exist. The examples given were not really relevant to this case. And ultimately, what decides this is whether 6 Lord Justices agree with one position or the other, because it just has to be a majority vote. Then Lord Wilson came onto a point. So again, and this is one of the things that the government had difficulty with here. So Lord Wilson said, is there any person better placed to defend the precious legal principle of parliamentary sovereignty than us here, referring to the Supreme Court? So Eadie then was saying, well, decisions about prorogation are inherently political and therefore non-justiciable. And it's the political judgments, not the legal standards here. But Lord Wilson then said, but is this about a political decision or defending a precious constitutional principle, parliamentary sovereignty? And I thought that was a lovely point, because it turns the issue on its head. From the prerogative power, so Sir James Eadie is arguing the Prime Minister has this prerogative power, which they do, that's fine. But then there's the counter-argument that at the moment this doesn't really happen. In fact, this may be unprecedented. But you have a situation at the moment where the Prime Minister exercising that prerogative power is in direct contradiction to Parliament being sovereign. You know, he's opposing parliamentary sovereignty. And in such a situation where there is a clash, one of them surely has to make way. And which one is it? And what Lord Wilson is making the point is the Supreme Court are the guardians of parliamentary sovereignty. So that may suggest, and I don't want to read too much into it, I'm not qualified to read anything into this, that the Lord Justices will not accept an argument that Parliament could have acted to stop this because they're not currently sitting. You know, that's what I mean. We've got this clash between parliamentary sovereignty and prerogative power. Maybe they will take the view parliamentary sovereignty is more important. And it's certainly the job of the courts to defend parliamentary sovereignty. It's not their job to defend, you know, prerogative powers, which are really a matter for Parliament to assign. So Eadie was asking a question about this. You know, what do you mean? And Lord Kerr then came in, he was the deputy on the panel, said, so what if a Prime Minister wanted to stifle debate by, say, proroguing for a full year? To which Eadie says that be very careful about establishing principles by testing them against extreme circumstances. There are political controls based on the need for it to sit. Now, there are not that many. There are some. For example, Parliament has to vote on budgets. So when the government runs out of money, it's going to need Parliament to sit again. But actually, for most of the time, if the government isn't that bothered about legislating, if it doesn't care about, if it just wants to carry out executive powers, I'm not even going to say duties, because duty doesn't even come into it at this point. They don't need Parliament for that. They don't want Parliament for that. So, and also given Boris Johnson's recent behaviour and rhetoric of more extreme behaviour to come, is it an extreme circumstance, proroguing for an excessive amount of time? Because it didn't need to be a year. He could have just said 6 months. The point's still the same. And then Lord Sales said, if there are constitutional provisions to be enforced, shouldn't it be for us to decide, the court, rather than for the Queen? Because, of course, we have a fundamental principle in this country that you do not politicise the Queen. Eadie says, yes, but those are matters for political control involving ministers. But are they? By the way, Lord Sales was the guy who had Sir James Eadie's job before Sir James Eadie. He's his predecessor. And, you know, at this point, again, you very much get the point. They're giving him such a hard time, the judges. You get the point. They're not at all impressed with his answers. They weren't at all impressed with Keane yesterday. And you can sort of get the impression, oh, this is going really well, isn't it? Not legally trained. I was reminded by constitutional experts who follow these sorts of matters as part of their career, not to read too much into it at all. From their questions or from the demeanour or the responses, you can never know what those conclusions are going to be. You can never prejudge them. Now, there did come a point where there was a lot of emphasis on the bills being lost. Now, at any one time, of course, there are various bills going through Parliament, and when it's prorogued for a new session, those bills are lost. So when you start a new session of Parliament, any bills that were making their way through Parliament are just dropped. You can try and pick them up again. You can carry some over if necessary, but they're essentially dropped. And that's a shame. The problem is the focus on it was totally irrelevant. I thought a waste of time. For example, if Boris Johnson had prorogued for a new session and suspended Parliament for 1 week to prepare for it, nobody would have gone to the courts. Those bills would have been abandoned anyway. This has nothing to do with the time it's prorogued for. So that was needless time wasting, I feel. So there we go. But they wasted a bit of time on, well, I thought they wasted time. Obviously, I'm not a judge. I thought they spent quite a lot of time on that. Then Eadie was saying that the court normally identifies the will of Parliament from enacted legislation. How can you decide what legislation Parliament would have enacted in this case? So that takes the court into political controversy. How can you say Parliament did not have enough time to legislate? I mean, they didn't, but I'll come to that in my second video today. But at this point, it was almost sort of saying that the prorogation, he doesn't even care that the prorogation was for the Queen's speech or not, because that's the official line. The prorogation was just to make way for the Queen's speech. Everyone knows you don't need 5 weeks for that. But it's like there's no pretense at this point. And that is a key point. Boris Johnson has lied about his reasons for prorogation. At no point has the government's advocate, either yesterday or today, even argued that point. The government's argument is that he can prorogue for whatever purpose he pleases, for as long as he likes, and that he doesn't even have to be truthful about his reasons. They didn't go in court and say he's a lying bugger. They tried to say, oh, no, he's absolutely truthful. But it's almost like they didn't care about what the reason was, even though he stated what the reason was. The attitude is very much, if Parliament didn't like it, they should have legislated against it. But, as the various constitutional experts I was following have said, that's not a great argument, because judges, it's essentially their job at times to make these sort of judgments. You know, in fact, there was a tweet I saw that was quite funny, that sort of this little passage of play, they sort of paraphrased it. And this is pretty much what he was saying. It was pretty much like, Sir James Eadie was saying to the court, who are you to judge these things? To which, although they didn't say anything, these 11 Supreme Court judges were probably thinking very loudly, well, we're the 11 of the 12 most senior judges in the country. That's who we are to judge these things. And we judge these things a lot. So that was quite funny. But again, Eadie banging on about it, says there are no standards against which you can test this decision. How can you assess the impact of this policy on individual rights? Talking about, no deal Brexit. The tools for the invention of standards are lacking. How can you decide which political advantage points are relevant or legitimate? And again, he talks about the 1949 prorogation, which was brought up yesterday, as a good example of legitimate political advantage. But Lady Black, who the president of the panel, came in, how can Parliament control prorogation? Eadie said it could have done so before, i.e. with legislation. The problem is it didn't have time. It barely had time to get through the legislation it needed to prevent the no-deal Brexit. Or he said afterwards, motion of no confidence. But in this particular case, of course, it's time sensitive. Afterwards can be too late. Because another point, and the barrister today again couldn't, ignore this fact. When this period of prorogation is over, Boris Johnson brings Parliament back for his Queen's speech. A few days later, there's nothing to stop him proroguing right again. If the court decides that the Prime Minister can do as he likes, he can just suspend it again for the rest of the month. So yeah, it didn't have time before, and it wouldn't have time afterwards if the court doesn't stop Boris Johnson taking the piss. And Lord Kerr was then saying to Eadie, well, look, what are the after the event controls? So this has now happened. Parliament is prorogued. Parliament isn't happy about it. Parliament is sovereign. What can Parliament do about it now? Eadie says that Parliament has 17 days after it returns. But like I say, it doesn't. If Boris Johnson prorogues Parliament pretty much straight away, they have no time at all. So I mean, that's the thing. Neither barrister has an argument for that. And again, I think this is where the barrister looked, to me, fairly foolish at this point, but they're not. They're just defending, I think, from a weak position. And that's, and that's what the judges were basically saying at this point. How can Parliament deal with misuse of prorogation if it's prorogued? How can it be a matter for Parliament only and not the courts if the executives prorogue Parliament so that Parliament can't do anything? That is one of the key points in this case, really. It cannot be the defence of the government that Parliament should have got into a time machine. We don't have them. Another thing he said, now I think this surprised a lot of people. Eadie said, this is a quote, "It is for the government to regulate the sittings of Parliament." That has to be a misstep. Surely has to be. The first Gina Miller case established that Parliament is superior to the government. Clearly, that's stated in law now, no argument about it. It's the Supreme Court itself who said that. It cannot therefore be argued that the government gets to regulate the sitting of its own checks and balances and its superior assembly. It's a bit like when you're due an inspection that day, telling your boss not to come into work, or as a teacher in a school, disbanding Ofsted, school inspectors. No, you don't get to do that. But he kept going on. He said recent events show that Parliament has the opportunity to legislate. He talked about the recent Northern Ireland Act, Section 3, which before summer they amended to try and make it so that Parliament would have to come back and sit and be given a report by the government. But then he also went on to say, but actually there'll be no need to give a report before October the 14th. So he's saying that Parliament were able to legislate to stop this thing, but then saying, but it won't work. Again, this is me being a legal duffer, I'm sure, but I don't see how that backs up his argument. And then he also said there is now primary legislation on a no-deal Brexit. How can the court say how much more time Parliament needs? In other words, what he's saying is no-deal Brexit can't legally happen unless Parliament votes for a deal. In which case, what are they whining about? What are they moaning about? The no-deal Brexit won't happen. But that's not the government's position. How do we know? How do we know they'll comply with it? Because that's what I would be saying. His barrister is basically saying, of course, Boris Johnson will sign that letter if the law requires him to. And the law will require him to. But do we believe it? I really don't know. So, yeah, I'm not sure the court's going to buy that as such. And apart from anything else, it's not just about those things. Parliament doesn't want to be sat indefinitely. And that's the key issue. And the judges themselves have come out with that. On both days, what you're basically saying is that the Prime Minister should be able to suspend Parliament indefinitely until something happens that absolutely requires Parliament, such as a budget or a general election. Now, at the end of it, there was a lot of questions about the lack of a witness statement and the lack of a sworn affidavit. The government have handed over what is clearly incomplete documentation. In fact, I'll read you out the passage that went there. So Lord Kerr was saying, was there a political advantage to the government from a 5-week prorogation? So Eadie then said, there is an advantage having a clear space to prepare Queen's speech. Then Kerr said, but it helps to render scrutiny impossible. So James Eadie at that point said, read the evidence. To which Lord Kerr said, but is it comprehensive? Is there enough evidence to go by it? And there are no witness statements. And he made the point, witness statements in this situation are the usual procedure. Why aren't there any? Why aren't there any? And that is the issue. And I saw David Allen Green, who's a commentator on this. He put the exchange, again, paraphrasing quite well. So basically, Supreme Court says, what was the true motive for prorogation? Government say, the evidence speaks for itself. So what does the evidence say? The evidence speaks for itself. In actual fact, you might imagine if the government lose this, they may regret not submitting that witness statement. Because a witness statement is usual procedure. The judges have all said that. These are the most senior judges in the land. The most senior in the land. And they are saying they expected signed witness statement from the Prime Minister or at least the Cabinet Secretary. That has not been forthcoming, and they've asked about this on both days and it's still not forthcoming. Why isn't it forthcoming? What can you draw from that? It's not enough to say, well, the evidence we've submitted is adequate. The judges who are going to decide this have just told you it's not adequate. So why are they not submitting it? It can only be because the evidence submitted so far is not truthful. But they would not dare lie in such a statement. Apart from anything else, then that would mean some cross-examining. And in fact, the QC, I'm going to go over into the second part of today's review, stood up at the end and said, well, there is a possibility here. You could get the Cabinet Secretary in for cross-examination. That would set a cat amongst the pigeons. But there you go. I'll just finish off with a little aside, by the way. So other little news that's going to go fall by the wayside if I don't mention it here. So in the European Parliament today, a couple of great things happened. Guy Verhofstadt was saying, it's fantastic, because Nigel Farage was causing trouble, of course. He says it's fantastic that the Brexit Party and Mr Farage are making so much noise because they can't do it in Westminster anymore. So they have to do it here. Jean-Claude Juncker and Donald Tusk cannot close the doors of our Parliament. And that Parliament, by the way, then voted on a motion that said, if the UK asks for an extension, do we give them one? And they voted overwhelmingly yes. So obviously, EU Council members all get the final say. But that is a strong commendation from the EU Parliament that the EU are absolutely not sick of us yet. I know some people don't agree with that, but they're not. And again, that puts more pressure on Boris Johnson. That reduces the chances of him hoping that if he has to sign that letter, and he will have to sign that letter, that he'll somehow get away with it because an EU Council member will say no. So anyway, second part will be out in an hour or two. Hope you found this one interesting. If you'd like to support the channel further, then please click the Patreon link for details. And until next time, I'll see you later.